All right, welcome back, everyone. How's everyone doing? Good. Hope everyone's doing well. My ear hasn't popped. I was on the plane yesterday, so I can hear from this ear, but barely this ear. So if I ask you to speak up, please don't get offended. It's been popped for almost 24 hours and it's driving me crazy. But eventually, this one unpopped. This one's still limited hearing, so I'll do my best today to hear. But I think I'll do okay. If I go like this, you'll know why. Thank you for the donuts. What was the occasion? It's Kirsten's birthday. Whose birthday? Happy birthday. Do we sing? Happy birthday to you. Happy birthday to you. Happy birthday, dear Paul. Happy birthday to you. All right, very good. That's very nice. I don't think any students ever brought in donuts for everyone. So for everyone else who has a birthday and no donuts, you know where you stand. I'm kidding. I think that was a joke. I think I heard laughter. Okay. All right. I need to make an announcement because the school asked me to, so I will. There's a joint JD MBA with Texas A&M, and there's an information session which the school wants you to go to on Tuesday. That's today. One at 11:30, another one at 3:45 in room 513. So if you're interested in a JD MBA with Texas A&M, go check out this information session. I've done my duty, so I will say no more. Let's see. Okay. So questions, anything in your mind from Obamacare, Commerce Clause, Necessary and Proper Clause, taxing power, anything else on your minds from last class? We had somewhat of an extended class, but I think we got just about everything in. Anything on your mind? Okay, very good. Well, today we're starting the next big chapter in this class. And what is this chapter? Limits on the state's power. So far, virtually everything we've done in this class focused on limits of the federal government's power. Limits imposed by the Commerce Clause, by the Necessary and Proper Clause, by the taxing power, and by federalism. There are certain limits that the Constitution imposes on the federal government. Our topic for the next few weeks is a very, very different question. Excuse me. What limits does the Constitution impose on the states? Okay. And if I were to ask you that question in 1789 when the Constitution was ratified, the answer would be none, really. The Constitution, as originally drafted, had very few restrictions on the states. They couldn't pass what are known as ex post facto laws. They couldn't impair contracts. They couldn't form treaties or keep navies during times of peace. But there was almost nothing in the Constitution placing limits on what the states can do to individuals. I mentioned a case before called Barron v. City of Baltimore. Okay, we'll do this case again later. But in Barron v. City of Baltimore, the Supreme Court held that the Bill of Rights, the first 8 amendments to the Constitution, don't apply to the states. So if a state wanted to establish an official religion, they could. In fact, most states at the time of the founding had official religions. So even though Congress could not establish a church, the states could. If a state wanted to punish free speech, they could do that. If a state wanted to take private property without compensation, they could do that. All the protections that we see in the first 8 amendments of the Constitution, which we'll study in this class, Fourth Amendment, Fifth Amendment, did not apply to the states. I can't stress this point enough because at the time of the founding, it was deemed that the states could be the proper guardians of the liberties of their citizens. Okay? They had state constitutions, they had state courts, they had state Bill of Rights. And the framers said, we can leave it to the states to protect the freedoms of the people. Okay? One of the only exception to this, if you take out your handy constitution, pockets in always, when I bring to the cleaners, I always forget which pocket I put it into. And if you turn to Article 4 of the Constitution, on page 33, this is one of the few exceptions in Article 4 where there are limitations put on the states. And we read Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Okay? What does this provision do? It's effectively a non-discrimination rule. That one state, say New York, can't treat citizens from New Jersey differently than its own citizens. That if New York affords any rights to its citizens, and someone from New Jersey comes along, it can't be discriminated against. These are these privileges and immunities. This is a, we might call a term of art. This was this body of rights. We'll discuss this later in a few minutes. Okay? So all the Constitution said was, you can't discriminate against citizens from another state. But herein lies the rub. Citizens. Who was a citizen of the United States? Who was a citizen of a state? And this should come not much of a surprise for anyone who studied American history, but slaves were not considered citizens in a significant portion of the states of the Union. As a matter of state law, they weren't citizens. Therefore, they were not entitled to these rights, these privileges or immunities. But even more strikingly, there was no such thing as American citizenship. We think today that you're a U.S. citizen, you have a passport when you travel abroad, your passport stamp USA. There was no provision in the United States Constitution saying, how does one become a citizen of the United States? This led, in no small part, to a decision we'll study later called Dred Scott, which I'm sure many of you have heard about. The case itself is actually somewhat banal. Believe it or not, this is going to blow your minds. Dred Scott was a case about diversity jurisdiction. I'm serious. We study diversity jurisdiction, right? When a citizen of one state can sue a citizen of another state in federal court. You did this in civil procedure, right? What happens if you're not a citizen? This was the jurisdictional aspect of Dred Scott people don't seem to care about. But the entire question was this freed slave, Scott, right, a citizen who could avail himself of federal diversity jurisdiction? If he wasn't a citizen, he couldn't avail himself of diversity jurisdiction and couldn't go to federal court to sue for his freedom. The reason why this case was so significant, beyond all the other historical mementos, was the Supreme Court said that a person of African descent could never be a citizen of the United States. We'll discuss this case in about 3 or 4 weeks. So, but what I want you to know for now is, as it stood with Dred Scott, a decision by Chief Justice Taney, people of African descent could not be citizens. Okay? So this was the state of constitutional law before the Civil War. The Constitution imposed no restraints on the states of any meaning, and the states were entrusted to protect the freedoms of the people in the states. Although, as history is a guide, that didn't work out particularly well, and many states continued to uphold slavery and treat people as not citizens and deny them all hosts of rights. And it was with this backdrop that we fought a bloody, violent Civil War. And we can discuss the causes of the Civil War. We can have an entire class on that. But needless to say, one of the key aspects was the clash between the northern view and the southern view. Okay? After the Civil War was fought, it wasn't just a military victory, but it was a legal and constitutional victory. Okay? What do I mean by that? We had a second framing of the Constitution. All too often, people think of the framing of the Constitution as 1787 and James Madison, right? And Alexander Hamilton and all these other guys. But in truth, we had a second framing of our Constitution. This was a period known as Reconstruction. Reconstruction wasn't simply rebuilding the South in terms of infrastructure and economy. It was rebuilding the nation in terms of a constitutional revolution. So I urge you, whenever people say the founding of the country, don't just think of 1787. Think of 1868. And in fairly brief succession, in a few years, like 4 or 5 years, we had 3 major amendments added. Keep in mind, after the first 10 were added in 1791, they had only added, what, 11, 12, 2 amendments since the Bill of Rights were added. One about state sovereignty, which we'll discuss next class, and the other about the election of the president, which is, not too substantive. It's a procedural measure. But in fairly short measure, 3 amendments were added to the Constitution. These amendments were drafted at a time, and I should stress this, when the southern states didn't have much franchise, right? The southern states, because they were considered rebellious, were basically excluded from Congress. They didn't have much of a say in how these amendments were drafted. And more strikingly, they didn't have much of a say about whether they would ratify. Because in large measure, the southern states were only admitted back into the Union if they ratified these amendments. So it's unclear if they actually had the requisite number of states. I don't want to go down that road, but as a matter of formality, it's unclear if they got the requisite 3/4 of the states. But that's somewhat water under the bridge. As a historical footnote, if I'm getting this number correctly, I think Mississippi ratified the 13th Amendment in the year 1995. I might be forgetting this. I think some law student or some law librarian said, hey, wait a minute, guys. We never ratified the 13th Amendment. So they actually went ahead and so now slavery is no longer permissible in Mississippi. It wasn't, but as a matter of course, Mississippi has now accepted this limitation, I suppose. Kentucky, I think, ratified in the 70s, if I remember correctly. But we now have these amendments which were added in fairly quick succession. Okay? So you might ask yourself, why do they need these amendments, right? Why were these amendments important? Why couldn't Congress just pass statutes protecting the freedmen? By the way, when I say the freedmen, I mean the freed slaves. That's the common word that was used. Freedmen, women included as well, but I'll say freedmen to be historically accurate, right? Why did Congress not merely pass statutes to protect the freedmen? Well, as a matter of course, they probably couldn't. What power was given to Congress to give them the authority to free slaves? What I'm about to say sounds very callous, but it's actually a serious legal point. The slaves were considered property. When the government takes property, they need to provide compensation. There was a serious fear that if they actually freed all the slaves with a statute, that Congress would be required to pay compensation to the slave masters. I am not joking. And lest you doubt me, when Abraham Lincoln issued the Emancipation Proclamation, do you know what the basis of that was? His war power over rebel property. The same way that when you're a general in a war and you attack a place, you're entitled to seize their property. If they have guns or cannons, you can seize them. What did Lincoln say? because the southern states are in rebellion, I will use my war power to seize all their property, including their slaves. And that was actually the legal basis on which the Emancipation Proclamation worked to free slaves in the South. The Emancipation Proclamation did not free northern slaves. Make no mistake, Maryland had slaves, other states had slaves. Kentucky had slaves, but he used the power to seize property, right? So Congress couldn't just pass statutes to free slaves. But there's a more important point. When you pass a statute, it can be repealed. At the time these amendments were going on, the so-called radical Republicans, the Congress was almost entirely Northern Republicans. The Democrats were Southerners. They were all excluded from Congress. They realized very early on that at some point the Southerners would come back into Congress, and they would try to repeal all these statutes. So the framers of the Reconstruction Amendment said, we need to make this permanent. We need to bake this into our Constitution so it cannot be revoked. Okay? And it was this basis that we had the 13th, the 14th, and the 15th Amendments in fairly rapid succession. And these transformed the Constitution in many, many ways. Okay? So let's start with the 13th Amendment. Okay? The 13th Amendment says very clearly, neither slavery nor involuntary servitude, except for punishment of a crime, shall exist within the United States. Okay? I want to stress this language for one very important purpose. God, my mouse doesn't work. Falling apart today. This is the first provision in our Constitution, and as it stands today, the only provision of our Constitution that limits the actions of individuals. It limits the actions of individuals. How? Slavery shall not exist. It doesn't say the states can hold slaves. It says slavery cannot exist. As a matter of history, who held slaves? Individuals. People. The framers of the 13th Amendment recognize the only way to eradicate slavery is to change our constitutional order and put this restriction on individuals. That holding slaves was considered such an evil, odious, and wicked phenomenon, this institution, that it had to be eradicated from the root. That individuals could not hold slaves. Okay? But it wasn't merely enough to declare slavery could not exist. That would be nothing more than a partial barrier. How do you enforce this? How do you make sure that people comply with this? That brings us to Section 2 of the 13th Amendment. And this is where Congress's powers start to enlarge. So I've told you before that all of Congress's powers must come from the Constitution. And I've said in the past, we look to Article 1, right? Article 1, Section 8, commerce, necessary and proper, taxing, postal roads, right? Our favorite ones, pirates, punish the pirates. And I told you at the time, those are the only sources of authority for Congress to act. After the 13th Amendment, no more. Their powers expanded. Now they have the power to enforce by appropriate legislation. We'll talk about appropriate later. But by some legislation, they can enforce this. So if some state was still allowing slavery, or even if an individual was holding a person as a slave, Congress can pass a statute criminalizing that activity and prosecute that person in federal court. No longer does Congress need to rely on local prosecutors in states to ensure there's no slavery. Congress can take matters to its own hands. and the federal government can ensure that slavery shall not exist. Okay? Seems easy enough, right? But the question becomes, what does slavery mean? Is slavery merely holding another person in servitude? Or does slavery mean something greater? As we're seeing Harlan's dissent in the civil rights cases. We have these badges of slavery, things that remind you of slavery. When when a private business has segregated theaters, or segregated rail cars, or segregated hotels where they don't admit blacks. Of course, no one's actually holding people as slaves, but are these badges or reminders, if you will, of slavery? These are open questions for the 13th Amendment, which we'll discuss in today's class. Second, so the 13th Amendment was in 1865. Not even a year later, Congress passed what was known as the Civil Rights Act of 1866. Okay? And I'm lecturing a little bit here, but we'll get to the cases in a minute, but I want to take you through this history quickly. Also, I can barely hear. So the Civil Rights Act of 1866 was designed as a way to ensure the freedmen had certain rights. Again, up until this point, the Constitution entrusted the states with the protection of rights of all people. That experiment didn't work out so well, as even free blacks, forget slaves, even free blacks were routinely denied rights of contract, rights of property, rights to work in a profession, right to appear in court to give evidence, to sue and be sued. So Congress said, okay, we need to fix this. These black codes, which were emerging after the Civil War, to put blacks back in a state of quasi-slavery, a place that we know as Jim Crow, which we'll discuss later. Congress says, we need to give to these freedmen rights that are protected by federal law. So it begins. All persons, not all citizens, all human beings that are alive, by virtue of being alive, if you're in the United States, you have the same rights in the states as are enjoyed by white citizens. It says it right there, that all persons, everyone, will have the same rights as white citizens. What are some of these rights? Oh, this is just a list. This isn't all of them. But it includes making contracts, suing, giving evidence, security of property, right? What are these rights that they speak of? These are viewed as the building blocks of becoming full, productive members of society. You can work. You can acquire property. You can make a contract. If someone cheats you on that contract, you can sue them in court and give evidence. This may be news to you, but for you, probably not. Blacks were not allowed to testify in court. So even if one person made a contract and the white guy breached, good luck going to court to enforce it. They were not allowed to give evidence, not allowed to file a lawsuit. There were systematic efforts to separate them from the legal apparatus to allow you to exist.
How did Dred Scott file?
That was the entire point. He tried to file in federal court, not in state court. And because he was a citizen, he couldn't use diversity jurisdiction. This is why Dred Scott was also so bad. It basically limited the slaves to suing in state court where they had no jurisdiction. Scott tried going to federal court where you have had federal jurisdiction to sue for his freedom, and he couldn't. We'll do Dred Scott later. It's a very interesting case for a lot of reasons. Okay? But the Civil Rights Act of 1866 did something interesting. It radically changed the way states have to treat their citizens. So the question is, did Congress have the power to do this? I think we can all agree that this was a very good statute. Its heart was in the right place, and it tried to help people. But let's take a step back and ask, did Congress have the power to force states to treat blacks who are not citizens under state law the same way as white citizens? Well, at the time, President Andrew Johnson, who was a supporter of the South, didn't think so. He vetoed this bill. Remarkably, right? We're not talking Keystone Pipeline here. He vetoed the Civil Rights Act of 1866. He vetoed it. But even more so, Congress overturned his veto with a 2/3 vote. That this was such a significant piece of legislation. Right? It's still unknown, and it's still an open question whether this was constitutional. Could Congress, under the 13th Amendment, do this? It's a close call. But the issue was largely mooted 2 years later with what became known as the 14th Amendment to the U.S. Constitution. I don't speak in hyperbole when I say this was the most important amendment in the history of our Constitution. Forget the first, forget the second, forget the third, right? Those are all nice. But this made the provisions of the Constitution applicable to the states. This is where all the magic happens. This is why so much of our class is based on these few words. Yes, if I don't hear, just raise your hand, yeah.
You said this made what applicable to the states?
The provisions of the Bill of Rights. I'll discuss more of that in a minute. Yeah, if I don't hear, just shout louder. You're on my bad side, so sorry. Not my bad side, but my bad ear. My grandpa was in World War II, and he was on a boat that was hit by a kamikaze, and there was an explosion on one side, so I always had to talk to him on the other side, and now I can empathize. So, the 14th Amendment attempted to bake into the Constitution, insert it in a hard, unremovable way, these ideas, such that no future Congress could ever remove it.
Did that make very bad law?
The Supreme Court would eventually say that, but not right away. We'll discuss that later. But yes, more or less, kind of. There were three main goals, or actually four main goals, with the 14th Amendment, and I've highlighted them on the screen. Okay. The very first order of business was to reverse Dred Scott. The very first order of business was to reverse Dred Scott. Actually, not reversing, but prove it's no longer valid. The very first words. All persons. Doesn't say black. Doesn't say white. All persons born or naturalized in the United States are citizens of the United States and, this is the key, and of the state where they reside. Okay? This got rid of Dred Scott. If you were born in the United States, you are a citizen of the United States. But not only that, you are a citizen of the state in which you reside. No longer could a state tell a black person, oh, because of your descent, you can't be a citizen, and all the rights given to our citizens, sorry, you can't have those. With this amendment, in theory at least, everyone born in the United States is a citizen. This was often called birthright citizenship. Many countries in the world don't have birthright citizenship. Many countries, you need to have a parent or parents who are citizens. The United States is actually fairly unique in that regard, that merely by being born, by accident of birth you get citizenship. But that was how the framers dealt with the fact that you had all these slaves who came here, generation after generation were born, and they became citizens. Also, this word naturalized. This was Congress's powers to admit aliens from foreign countries, immigrants. So the first portion of this, what's often called the Citizenship Clause, Citizenship Clause, gives citizenship to the freedmen and everyone else. So now you have to ask yourself, all right, we have a citizen of the United States and citizen of the states. Are these the same thing or are they different? Are there some rights for U.S. citizens and different rights for state citizens? That's the thrust of the Slaughterhouse cases, which we'll discuss in a couple minutes. Okay. The second provision is probably one that you never heard of before this class, although I've mentioned it several times. The framers of the 14th Amendment wanted to find a way to guarantee certain rights to all people in all states. And to do this, they seized on this language: privileges or immunities. Privileges and or immunities. A few moments ago, I showed you in Article 4. There's the Privileges and Immunities Clause. Please don't confuse them. It's a pet peeve of mine. The justices even mix these up. It drives me nuts, right? So Article 4 of the Constitution is a Privileges and Immunities Clause. The 14th Amendment, privileges or immunities. Don't mess this up in your exam. It'll just make me annoyed, okay? They're different. Phrased differently. But the idea is in the ballpark. It's a similar idea. What are these privileges or immunities? Well, that's a controversial topic, and people don't agree. But if you look at the statements of the people who framed the 14th Amendment, John Bingham, Jacob Howard, among others, certain ideas come through. One of which is that it includes rights protected by the Civil Rights Act of 1866. Rights of contract, rights of property, right? These are certain economic building blocks to make yourself a full person. This might be what's called as the right to pursue a living, right? If you want to work in a certain way, you can do that. Government can't tell you not to. But, and this was Jason's question a few moments ago, what are the other privileges or immunities of citizenship? Well, if you look at the framers of the 14th Amendment, they also seem to make clear that these privileges and immunities included the first 8 amendments to the Bill of Rights. This was the big deal. This imposed the Bill of Rights on the states. The states could not censor free speech. They cannot violate the right of trial by jury. They cannot deprive people of the right to bear arms. They cannot search a person's home without a warrant. This provision that states can abridge these privileges or immunities was meant to extend the Bill of Rights to the states. It's hard to even exaggerate how significant this was. At the point, the states were free to do whatever they wanted. If their state constitution had a guarantee of free speech, great. And if it didn't, too bad. But now, the states were required to comply. Now, the Supreme Court didn't agree with what I just said. We'll see why the Supreme Court basically ignored the 14th Amendment. What I want you to learn, and you know the truth, is that this clause, no state shall make or enforce any law which shall abridge the privileges or immunities of citizenship. This was meant to be the crown jewel of the 14th Amendment. This was meant to do all the heavy lifting, to guarantee to the freedmen, these new citizens, all of these rights which free people should have. Okay, this was the big deal. And we'll see in the Slaughterhouse case, which we'll discuss in a couple minutes, the Supreme Court gutted it. In the Slaughterhouse cases, the Supreme Court basically read this clause out of existence. They pretended it didn't exist. They limited it to a certain subset of insignificant rights that don't even matter, like accessing the Treasury, protection of the high seas. Everyone today, and I don't say this as a right or left, but everyone agrees the Slaughterhouse cases were wrong. When you read it, they're wrong. They were making a mistake, and I'll explain why they made the mistake, but the decision was wrong. But as a matter of history, this was the crown jewel. This was meant to do all the heavy lifting. Okay? So at least you guys know the truth, even if the Supreme Court is not so inclined. Okay? The second main provision we'll talk about is one you've probably seen before. It says, nor shall any state deprive any person of life, liberty, or property without due process of law. So this provision had been in the Bill of Rights, in the Fifth Amendment, for almost 70 years at that point. But now, states cannot deprive people. Now notice, it doesn't say citizens. Any person, citizen or not, cannot be deprived of their life, their liberty, or their property without due process of law. We will spend a significant amount of time on this phrase in about a month or so. But for now, what I want you to remember is that this now puts limitations on certain procedural and substantive rights of people and states. Okay, we'll come back to due process later. The final provision, the third one, which is one most people know about, is what's called the Equal Protection Clause. It says, nor shall any state, quote, deny to any person within its jurisdictions the equal protection of the laws. Okay? What does that mean, the equal protection of the laws? Does that mean the laws have to apply equally to people? So say you have a law that says you can only marry someone of the same race. Well, that means a white person can only marry a white person, a black person can only marry a black person. That law is equal, right? Law is being applied equally. Well, that's what some people argued it meant. Or does it mean the law can't make a classification based on race, right? That you can't have a statute that conditions marriage based on your race. We'll do that as well. So I'm going to footnote that for now. But the mere text of what equal protection of laws isn't entirely clear. All right? I want to scroll down now to Section 5 of the 14th Amendment, which will be the subject of our class next time. Much like the 13th Amendment before it, the 14th Amendment has what's called enforcement powers. That Congress has the power to enforce the provisions of this law. Right? If a state is not treating people equally, Congress can create a cause of action to stop it. If a state is denying a person due process of law, Congress can enact laws to protect it. One law I'm sure you've seen is 1983. Everyone know about this? Where you can sue a federal official. You can sue a state official for messing up. 1983 was originally called the Ku Klux Klan Act. That allowed people to go to federal court with a federal judge and a federal jury and sue a state official for not protecting its civil rights. This is a very significant way, because the way you make people comply is in their pocketbooks. and we start getting federal judges enforcing orders against state officials, that's how you make magic happen, to an extent. But the limitation of the 14th Amendment is this. State. While the 13th Amendment limited individuals, slavery shall not exist. The 14th Amendment limited states. States can't deprive you of your privileges or immunities. States can't deprive you of due process. States can't deprive you of equal protection. What about individuals? What if their private business won't serve blacks? A hotel, a restaurant, a theater, a train. So we already gave away the ending of this because we studied in the 1960s, Congress passed under its commerce powers various civil rights laws. We did Hearts of Atlanta Motel, remember that case? And Cats and Vacuum McClung, this was the Ollie's Barbecue case. We did these cases, so you know how this ends. Because eventually Congress relies on its powers over interstate commerce to eradicate discrimination in public places. But the court didn't think about the Commerce Clause back then. They thought about using their Section 5 powers. Just so you know in the future, when I say Section 5 powers, I'm talking about Section 5 of the 14th Amendment. It's a shorthand. When I say Section 5 powers, I mean the enforcement powers in Section 5 of the 14th Amendment, just so you know that, because I'll use that phrase a lot. All right? So in the last case we'll study here, the civil rights cases, the Supreme Court will address whether Congress can reach private actors, businesses, through the 14th Amendment. And not to give the game away, by a vote of 8-1, the Supreme Court said they cannot. By a vote of 8-1, the Supreme Court said the 14th Amendment does not give Congress the power to control behaviors of private businesses. That was the holding. All right, that was a lot. That was a 45-minute introduction to the Reconstruction Amendments. I didn't get to the 15th Amendment. The 15th Amendment guaranteed the right to vote, okay, on the basis of race. Yes, sir.
While we're talking about the 14th Amendment, on the little last section that we talked about where it says, nor denied to any person within the jurisdiction of equal protection of the law. They purposefully put any person to mean anybody that's not a citizen.
Yes.
Today specifically,
Yes.
like with immigration and stuff, you can't deny them rights.
Yes.
Yes. So I think I heard it. So you raise a very good question. The question was in the 14th Amendment, you have for privileges and immunities, citizens. For due process, persons. And for equal protection, persons. Equal protection and due process is much broader. They apply, as he said, to immigrants, anyone traveling through the country. And I'm sure you did a case in Fourth Amendment called, you did Prim Pro yet or no? There's a case called Verdugo or Quides, which basically means that if you are in the United States, you get your Fourth Amendment rights. And this is a weirder one. If you're a United States citizen and you're abroad and there's a federal agent there, you get your Fourth Amendment rights. So I think the case was this guy was right over the Mexican border and he was being apprehended by customs or someone, right? And they basically searched him without a warrant, right? You're a U.S. citizen, you still get your rights. So the mere fact that you're a citizen or not does not deny your rights. Interestingly, the courts held, and I think these are probably wrong, that Second Amendment rights do not apply to resident aliens. I don't think that can possibly be right. If you get your First Amendment rights, you get your Second Amendment rights. It's a package deal. You only get both of them. But the courts have held that resident aliens who are here lawfully do not get Second Amendment rights. I think that's very, very wrong. Anyway, we'll wrap up with the 15th Amendment, which was meant to ensure that the right to vote was not denied or abridged. But unlike the 14th Amendment, which makes no mention of race. If you notice that, there's nothing which says blacks and whites are treated equally, or blacks given equal rights to whites, whatever it is, right? It just says equal protection, period. The 15th Amendment is a lot more specific. It says the right to vote cannot be abridged, quote, on the basis of race, color, or previous condition of servitude. Okay. What about women? Right? I'm sorry, someone say something? I have got this vague sense of hearing that's kind of freaking me out. What about women? Could women vote? And this was a topic of one of our cases for today. But if you look at it very closely, it says race, it says color, it says condition of previous servitude. A lot of women thought that this gave them the right to vote, but not quite what the courts held. And that about 40 years later, we got to the 19th Amendment, which if you want to flip to your constitutions, 19th Amendment's on page, someone call it out, not that I could hear it, page 52. And it says on page 52, the right of citizens of the United States to vote shall not be denied or abridged on account of sex. So it took a second amendment, not the Second Amendment, but a subsequent amendment to extend the franchise to women. Everyone with me so far? All right. All right, so this is your crash course on the 14th Amendment. I know I went probably a little fast, but you need to have this history before we get to the cases. Are there any questions? I'll do my best to hear. Questions? All right, everyone get the general gist of the history? Okay. So this was the basis on which all of these amendments were drafted. The very first case, which I ask you to skim in part and read in part because it's way too long. The very first case in 1873, where the Supreme Court was called upon to interpret the 14th Amendment, was a series of cases known as the Slaughterhouse cases. The Slaughterhouse cases. Now I'll give you a brief summary of the facts. I didn't actually ask you to read the majority. The city of New Orleans, I'm sure many of you have been there, passed a law. And this law said, if you're a butcher in the city of New Orleans, you are required to bring all of your livestock to be slaughtered to this one location. They gave a monopoly to this one company. If you have a butcher shop somewhere else in town, it's closed. We're shutting down your business. You are required to come to this one company, pay whatever rate they set, and that's it. Okay. Are you leaving? I was about to call on you too.
Oh.
That's good.
Wait.
Okay. You get a quick one, right? So you heard the setup, right? How this law works, right? What do you think the purpose of this law is? Why do you think the good old boys in New Orleans enacted the statute? What do you think their motivations were? Money. Why money?
Our law has all the power to sell everything in their hands, right?
Well, why would the legislature pass this law? I know why the businesses would want it. Why do you think? Be cynical. Be really cynical.
I don't know.
What do you think, you? Be cynical. I got to be louder.
Take power out of one group's hands and turn it into the other.
Why? Why would they do this?
Oh.
Be more cynical.
To get their votes, to get say how much money.
Money. Okay. This is what we call but political money, right? Follow me here, right? the city didn't own the butcher shop, right? The city didn't own the slaughterhouse. The slaughterhouse was given a monopoly to one company, right? That one company, no doubt, supported significantly the politicians who enacted the statute. You see that? Yeah. You were close. You were close. This is what we call rent seeking. You don't hear the phrase rent seeking? You know what that means? Governments can hand out benefits. They can grant monopolies. Generally speaking, governments hand monopolies to the parties that give them the most stuff, which is what we call campaign donations, or in New Orleans, we call those bribes. This was a pure naked power grab. They were basically putting out of business every butcher shop except for one. Every single slaughterhouse in New Orleans was now illegal, except for this one preferred company. Now you may say, well, Josh, wasn't this a regulation for health and safety and all that other jazz, right? Well, I hate to break it to you, but in the 1860s, with all respect, New Orleans wasn't exactly the cleanest place. And this wasn't primarily a statute that was geared for public safety because there weren't many rules saying how this one slaughterhouse had to behave. I actually have a picture of it. I'm like an idiot with this thing, right? I have a picture of it here. My trackpad also broke over the weekend. It's been a rough week. This is actually the slaughterhouse. And what's interesting is that even though this law granted a monopoly to this one company, there were no actual requirements of how this company had to slaughter their various animals. Okay, so the statute was passed, right? Jonathan, how do you think the other businesses, the other butchers in New Orleans, reacted to this new law?
I'm gonna assume they went to use that.
Why do you think they were not happy about it?
They were losing their businesses. And
Yeah.
they were, like,
Look.
trade.
Once this statute went into effect, the businesses were shut down. They were required to bring all of their animals to this slaughterhouse to be slaughtered. So, Lauren, before the 14th Amendment was ratified, would these butchers have had any remedy to go to court to stop New Orleans from passing this law before the 14th Amendment?
I don't think so.
Why not?
Well, because they used the 14th Amendment to go to court.
Well, I know that. But was there anything in the Constitution before the 14th Amendment that would have allowed them to go to court?
No, I mean, most of the rights that would be related to something like working in the city is reserved for the states, and so I think they would have just said, sorry.
Yeah, exactly. Before the 14th Amendment, there was absolutely nothing in the Constitution that would have prevented this. So the question the Supreme Court has to face here is, did the 14th Amendment change? Right? Did the 14th Amendment change this calculus? Did the 14th Amendment impose restrictions on state laws? Okay. So the butchers filed a lawsuit. Interestingly enough, they didn't challenge this after that due process of law. I think they could have, right? They could have said, look, they're taking away my business, my butcher shop, without any due process. They could have done this. They could have said, well, you know, you're depriving us of the equal protection of the law because you're treating this butcher different from everyone else. But they brought suit under what at the time people called the crown jewel of the 14th Amendment, the Privileges or Immunities Clause. Okay? They brought suit under this. And this wasn't a surprise because everyone at the time thought this was where you get your rights from. And what was the right they asserted under the Privilege or Immunities Clause? This is what became known as the right of contract. The right of contract. The right to pursue an honest living, as we may call it. That if you're in a lawful profession and you're complying with all the regulations, safety, health, whatever, the government can't tell you how to make a living. We'll discuss this right later in the context of what's called substantive due process, and a very famous case called Lochner versus City of New York. But I'll preface this by saying this right of contract has been deemed probably the most controversial rights in the Constitution. Mainly because progressives don't like it because it gets in the way of progressive legislation. But the idea is, if you want to pursue a calling, the government can't tell you no. The government can't tell you how to make your living, right? So here the butcher said, wait a minute, we have this privileges or immunities clause. It guarantees our right to earn a living, our right to contract. If we want to run a butcher shop, then we can run a butcher shop. You can maybe tell us how to keep it safe for health, whatever sanitary conditions, but you can't tell us to close our business. That is a bridge too far. So the suit was challenged in court. The majority opinion, which again I didn't ask you to read because it's long and wrong, they're two bad combinations. The majority opinion explains like this. It says, well, you have citizenship of the United States and citizenship of the states. All that the 14th Amendment does is that it guarantees to people certain rights of federal citizenship. Let me say that again. After fighting a bloody civil war and imposing this massive restructuring of our political rights in our system of government, the Supreme Court reads it so narrowly to say that the 14th Amendment only guarantees certain very small aspects of federal citizenship. This, my friends, is a crock. It's risible. It's laughable. What are some of these rights of federal citizenship that we fought a bloody civil war over? The court lists the right to petition the government, the right to protection on the high seas, the right to access treasuries. This is a joke. With this opinion, the majority reads out of existence the Privileges or Immunities Clause. It limits it to certain insignificant rights that are far-fetched. What about the provisions of the Bill of Rights? I told you a few minutes ago that the senators who ratified this said, let's give people the right to free speech and due process and everything else. The court doesn't even touch that. As a result of this decision, which is horribly wrong, to this very day, the Supreme Court has never recognized the Privileges or Immunities Clause and given its proper place. There was a decision in 2010 called McDonald v. City of Chicago, which was ostensibly a guns right decision. But the challengers argued that the right to keep and bear arms should be extended to the states as a privilege or immunity of citizenship. And in fact, there's a very good case. The freedmen needed guns. Why did they need guns? To defend themselves against the Ku Klux Klan. There's actually a great exhibit on Rosa Parks. The Library of Congress released some of her papers. And she tells this harrowing tale of how a grandfather would basically sleep with his rifle under his pillow, pretty much, to guard himself against the Klan every day came by. Guns were a very essential part of self-defense in the wake of Reconstruction. But in any event, the Supreme Court said, nah, we're not going to do it. Slaughterhouse maybe was a mistake. We're not going to revisit that. 100 years of error, we'll leave it as is. The second thing I want you to learn is that in addition to gutting the Privileges or Immunities Clause, what happened after that was the Supreme Court went down the line. They said, all right, we're not going to reverse Slaughterhouse. Let's focus on due process of law. So invariably, almost all the heavy lifting in our constitutional order is done not by privileges or immunities, but by due process of law. Jason asked before, how were the Bill of Rights extended to the states, right? Why is it that Texas can't ban flag burning? It's been the due process clause. So rather than following the correct path of the Privileges or Immunities Clause, the Supreme Court said, yeah, The Due Process Clause says you can't be deprived of liberty. Free speech is liberty. Therefore, states can't deprive you of it. It's been through the Due Process Clause that the Bill of Rights has been extended to the states. This is not correct historically, but that's what's happened. Okay. Yes.
When you're talking about like you can't take someone's business from them, like with eminent domain, if like someone were to own like the like structure that their business was in, does that mean that like they couldn't by eminent domain take
Well, they could, but
business?
that's to pay for it.
But
Right.
what- Yeah,
You provide just compensation. Did any of these businesses in New Orleans get compensated for having their business shut down? No. So the rub was, New Orleans said, hey guys, shut down your business and we're not gonna pay you for it.
so if someone's business couldn't, like it needed, it only thrive because it was in a certain area, they could still take away that person's.
So this is more of a property discussion, but generally speaking, under the Supreme Court's precedent, Kelo, DC New London, if the Supreme Court if the state determines that a Hotel 8 would be better served by having a Ritz-Carlton in that area, the city could condemn them Hotel 8, or Motel 8, whatever it is, right?
Yeah.
I think you say Kelo on property?
Yeah.
Right.
Another hand? I apologize if it gets so close. It's I'm trying my best to hear it. All right. I want to draw your attention to the dissent of Justice Field, where Justice Field says, this is ridiculous, right? We just fought a bloody civil war to guarantee to the freedmen this entire body of rights. By the way, a lot of these butchers were black. This is like an unstated element, but this is also means to discriminate against people in a profession that was very easy to get into. You don't need significant training to be a butcher, right? It's you chop. This is not like being like a tinsmith or a newspaper man or something. This is a fairly easy profession to get into. Justice Field says this is ridiculous, guys, right? Of course, the state has its police power to regulate health and safety, but he calls this a, quote, naked case, naked, that they're simply punishing people who want to pursue a living. And this is a very important question, that states and the cities cannot pass laws which violate this freedom of contract. He says, if the majority is right, then the 14th Amendment was a, quote, vain and idle enactment. It won't do anything if this is the right interpretation. He says, the 14th Amendment was meant to protect the rights of contract. It was meant to protect rights concerning free labor. So Field says this is a terribly wrong decision. Okay, Justice Bradley concurs, and he makes the point more strongly. This was going to be the first in a series of steps by the southern states to put stumbling blocks in the path of blacks working. If the state can put limitations on where you can work, they can put limitations on your paycheck. And if they put limitations on your paycheck, you are not a free person because you can't support yourself. You're basically destined to poverty. Things like sharecropping, peonage, and other statutes that came after that were premised on this. Okay. Now, I want to offer a partial but not very strong defense of the majority opinion. And I'm going to say partial because I don't actually believe this, but I'm going to do my best to offer a defense. Let's see. Sarah, what would have happened if, in this case, the Supreme Court held that, yes, states can't pass these laws? And let's say in the other case, they held that, yes, states can't segregate their train cars. And they said, yeah, you know what, states can't segregate their schools. What do you think the southern states would have done in the 1870s and 80s if the Supreme Court said, yeah, you can't have segregation? What do you think? Yeah. So the point I want you to grasp, I'm not defending it, is the Supreme Court was acting in a very precarious time. We had just fought a bloody civil war, which did not end with agreement on all sides, shall we say. That Reconstruction meant you had Union generals in the South for decades supervising cities, telling them how to manage their affairs. There was a serious growing resentment among Southerners in particular about the race issue. And had the Supreme Court told them in 1870s that you can't discriminate, I think we would have seen something far worse would happen in the 1960s. We discussed the Little Rock 8. Right? These students went to high school in Little Rock, Arkansas, where the governor stood there in the door of the school, telling them to stop. You have Governor George Wallace saying segregation today, segregation tomorrow, segregation forever. That was in the 1960s. If it earlier, we might have had another civil war. I don't say this lightly to defend it, but I want you to understand the context which the Supreme Court was ruling. That had they made these decisions that went the other way, they would have probably been ignored. And in many respects, they were ignored. So here we have a case involving the right to vote. We'll do this case in a few moments, right? The Supreme Court said, oh yeah, you can't discriminate based on the right to vote, based on color, but there's this one sentence that says, but you can do it based on education, right? You can limit the right to vote to people with education. This gave birth to what are known as literacy tests. You ever seen these? These were these tests which were impossible. I mean, I've actually looked at them. I would fail it miserably. Ask you to like recite the entire Constitution, right? And these were tests given only to blacks as a means to disenfranchise them. And I use this as an example to show just because a court says something doesn't mean states will comply. And the states became very good at crafting an entire system of laws to achieve the exact same results of segregation and slavery. If you have a vagrancy statute, you know what that is? Some southern states said, if you don't have a job, you're a vagrant, and we can arrest you for that. You know what the punishment for vagrancy was? Slavery. Bet you didn't know this. So go back to the 13th Amendment. What does it say? Neither slavery nor involuntary servitude except as a punishment for a crime. You ever notice that part? Except as a punishment for a crime. So southern states enacted vagrancy statutes that if you were walking around unemployed, you were a vagrant. Therefore, you could be enslaved for some period of time to pay off your debt. And guess who owned these slaves? The states. States actually had penal colonies where they kept slaves working the fields to punish and pay off the debt for being a criminal. Right? You can do an entire course on this. I only have a few moments to discuss it. What I want you to understand is the Supreme Court was not operating in a vacuum. It's very easy for us to sit here in the year 2015 and look at this in our history books and say, oh man, Supreme Court messed up. But they weren't that dumb. I mean, they were dumb for sure, but they weren't that dumb. I think they recognized that this would not have even worked. But I don't offer that as a defense, but I'm trying to put context into it. Okay? All right, so any questions now about Slaughterhouse? What you have to know is this case basically gutted the Privileges and Immunities Clause and read the 14th Amendment so narrowly to give it virtually no meaning.
There's a reading that kind of deal. You mentioned McDonald, and Justice Alito said that he used the due process clause to get to that. Thomas read a concurrence that he used the immunities and privileges to get to that. And then I found an article where Professor Barnett, from your book, said that he thinks that that's a restoration of the Immunities and Privileges Act. Do you agree with that?
So Jason's question involves a case called McDonald v. Chicago. This was a 2009 gun case. I wrote stuff with Randy about this. I'm somewhat partial, but my general sense is that the Supreme Court has given up on the Privileges and Immunities Clause. They've recognized that this has been done. A mistake was made 120 years ago, whatever, 130 years ago, whatever it is, and they're not going to go back and fix it. So one interesting part, and this is actually, there's not a good answer, is that it applies only to citizens. And this is what Nephew said a couple minutes ago. If we, in fact, relied on privileges and immunities, then non-citizens would be out of luck. So one of the virtues of the due process clause applies to all persons, like you said a few minutes ago. But to answer your question, I don't think the court's going to revisit this. I think it's a done deal. Other questions on Slaughterhouse or privileged communities? This is near and dear to my heart. I've written a couple articles on this. I actually was very involved in the McDonald case. I went to the court for that day. I spent the night online. I was very cold, but it was worth it. Any questions on this one? All right, let's go to Bradwell. So Bradwell is an interesting person. She was a pretty cool lady. So this is her. So she was a married woman who learned the law, and this is a term of art. So law schools are actually a fairly new thing. For most of American history, if you want to be a lawyer, you were an apprentice. You'd go to a lawyer, you would sit in his office, and you would read the law with him, and do whatever he asked you to do. And then afterwards, you could then sit for the bar exam, the same way you have law school today. In fact, in Virginia, where I went to law school, you can still do this. They still have apprenticeships. Some states have it. They're fairly rare, but it works. So Bradwell read the law with her boss, her apprentice. It may have been her husband. I'm not sure, but I think it was. And she sat for the bar, and she got a really high score in the bar. So then she went to the Illinois Supreme Court and said, "Hey guys, give me my law license. I want to be a lawyer." And the Illinois Supreme Court said, wait a minute. So it's interesting, and this is something which you may never thought about. The laws that existed then didn't even consider the fact that a woman would want to be a lawyer. I'm almost positive that whatever statute existed simply said any man who applies for the bar, as a matter of course, right? But usually the phrase man is used in a general context. You said, hey, wait a minute. There's nothing in the statute that says women can't get it. And they denied her law license. So Bradwell went and filed a lawsuit. And she filed it under our favorite, the Privileges or Immunities Clause. And she said, wait a minute. I want to have my living. I want to work as a lawyer. That's my career vocation. I passed the bar. I have all the character and fitness and everything I need. Let me in. Let me in. Okay. This case was decided on the same day as Slaughterhouse. She didn't challenge this under due process of law. She didn't challenge this under equal protection. I mean, I think this would be a pretty good equal protection case, and that women were not allowed to admit to the bar. I think that's that's in the ballpark, right? But she said, crown jewel, privileges or immunities, right? So Demi, what did the Supreme Court say in a fairly short opinion, it wasn't very long, about her privileges or immunities claim?
They said that the admission to the bar was right reserved to the states. The state had that right to deny it.
Is there any right to be a lawyer? What did the Supreme Court just hold 5 minutes ago? What were these privileges or immunities? What were they limited to?
Citizens.
Louder, please.
Citizens.
Federal citizens, right? So in the Slaughterhouse cases, they said the privileges and immunities are these federal rights. Remember, the access to sub-treasury and protection of the high seas, all these dumb things. Does this include becoming a lawyer, Demi? No, not technically not. The answer is clearly no, right? If the right to be a butcher is not included, then the right to be a lawyer is not included. So that's that was a logical following of Slaughterhouse. What's interesting is the concurring opinion of Justice Field. So I mentioned a few minutes ago that Justice Field concurred in Slaughterhouse. I'm sorry, dissented in Slaughterhouse and said, wait a minute. The 14th Amendment guarantees all these fundamental rights, this right to earn a living, right? So how does Justice Field square the circle? How does he reconcile ruling for the butchers but ruling against Miss Poor Bradwell? What does he say?
The only thing that I can really grasp from that is that a married woman is not capable of practicing law.
I'm sorry, a married woman what?
A married woman is not capable of practicing law.
Why? Just you can say it. It's okay. We're friends here. But actually, I want you to, because I want you to actually understand how patronizing it is. So go for it.
Well, I don't know. Because after I got past reading that, I was just kind of like,
No. Okay, no. So I'm glad you said that. I'm actually glad I said it. I want you to read this stuff because it's very good historical reference of how perceptions existed at various points in American history, right?
Didn't they say she got to protect her husband?
Yeah. So you studied property, right? Did you marital property yet? Okay, you will do that soon. Under American and English property, since time immemorial, a married woman had no independent legal identity. You'll study this in property. A married woman had no legal identity. That when the husband and wife married, it created this fictional third person, right? It was a fictional, entity, like Brangeline or something, right? It's a fictional person that exists in its own right. That worked. So, but any property the woman held before the marriage was deposited in this fictional third person. What Justice Field says is, wait a minute. Since as long as we can remember, women were domestic, right? They were for the home, to raise families, to raise children. They can't even hold property. And this point's actually probably accurate. They couldn't make contracts. So if a woman couldn't even make a contract herself, how could she be a lawyer? Right? He's like, this won't possibly work. He says, and this is probably the quote that made you uncomfortable. The paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator, and the rules of civil society must be adapted to the general constitution of things and cannot be based in exceptional cases. Was that it? Yeah. No, I appreciate that. We'll do some other stuff that's probably gonna make you squirm as well. I think I made this promise to you in the first day of class, but I promise you will be offended in this class. I promise you. I don't know when, but at some point you'll be offended, and that's not a bad thing. So the Supreme Court said Bradwell is out of luck. She can't get her license to practice law. But as a happy footnote, this is actually, these things don't always end well, but this one actually ended pretty good for her. She became a reporter, as it turned out, and she became so enamored about being a journalist, about writing about law in Chicago, that she gave up this lawyer pursuit. She really loved being a journalist. And as it turns out, years later, the Illinois Supreme Court reversed its decision and they granted her a license. And then 2 years later, the Attorney General of the United States made a motion to admit her to the Supreme Court bar. So this one actually ended pretty good. I mean, they made good on it eventually. So she became a member. This one was very cool. I found this in the Supreme Court. It's a letter from Susan B. Anthony to Myra Bradwell about her case. So this is a kind of a cool trinket, which she basically praises her for her Supreme Court case and her bar case. So her and Susan B. Anthony were buds. Okay, let's move on. By the way, this is no longer good law. In case this shouldn't surprise you, in the 1960s and 70s, well, in the 1970s, the Supreme Court held that women are a protected class under the Equal Protection Clause. But again, under the privileges or immunities, still dead letter. We shifted to equal protection, which is where modern day gender equality cases come from. All right. Any questions on Bradwell? Not a complicated case, but an interesting one. All right, Sam, let's talk about Minor versus Happersett.
That was about Virginia minor trying to register to vote.
Yep. So she tried to register to vote.
They turned her away.
They turned her away. Okay. Then what?
And she sued for violation of the 14th Amendment.
Okay. Good. So what provision of the 14th Amendment did she sue over? I'll give you a hint. It's the same one as the previous two cases.
States can't deprive any person
Of?
life, liberty, or property.
No.
Without privileges.
Yes. This was another, if you're sensing a pattern, right? It's another privileges or immunities case. I'll give you a hint. We're not doing any equal protection today. The answer will not be to the equal protection due process. So this is another privilege or immunity case. So she said, wait a minute. My right to vote as a citizen is a privilege or immunity of citizenship. But this case after Slaughterhouse is easy, right? Chloe, was the right to vote mentioned in Slaughterhouse as one of these few privileges or immunities? It wasn't. So this case is easy. But I think the case against her, as much as it might break your heart, is really easy. And for two reasons, right? We look to the 15th Amendment. Chloe, let me ask you this question. If voting was a privilege or immunity of citizenship, would Congress have needed to enact the 15th Amendment? In other words, if all citizens now have the right to vote by virtue of the 14th Amendment, would you even need something saying you get it regardless of your race? Why not? Exactly. The argument goes like this. If voting was a privilege or immunity of citizenship, this is redundant. If all citizens get the right to vote, you don't need a 15th Amendment. Okay? Everyone see that? The second reason, if you go to Section 2 of the 14th Amendment, this is, most people never even read this in their entire lives, but you will read Section 2 of the 14th Amendment. And Section 2 of the 14th Amendment speaks in terms of male voters. Okay? Effectively, here's how it worked. The 14th Amendment did not guarantee the right to vote, but it told states, hey, if you don't give the rights to vote to male citizens over the age of 21, we will decrease your representation. In other words, if male citizens over the age of 21, that means blacks, as we were talking about, if they can't vote, we will take away members of Congress and we will take away your electoral votes. So this is a way of, let's say, nudging the states to extend the franchise to blacks. They weren't required to, but they were punished. This effectively reversed the 3/5 clause, right? Now it's the other way. If you deprive the right to vote to blacks, you lose representation. But it speaks specifically of male citizens, not female. So unfortunately, Ms. Happersett was out of luck. She was not going to win this case. And as I mentioned before, it took till the 19th Amendment in 1920 to give the right to vote to the ladies. Okay. So any questions on minor? Yes.
Did you say why? Am I yelling now?
You're good. You're good.
Did you say why people keep using the privileges and immunities clause and not equal protection?
Okay. So the question was, why are people using privileged immunities? The short answer is because they lived through this, right? There were these massive debates in the 14th Amendment. These massive debates. People wrote articles and pamphlets. And everyone who wrote these articles and pamphlets said, this is the crown jewel. This is like the cornerstone of the Constitution, right? This is where all these rights come from. This is phrase, privilege and immunity. This was understood as a term of art, the same way we might use like certain words today to mean stuff. It had significance. So if you're a lawyer and you just lived through this, 5 years earlier, this ratification, you're going to try and give the amendment the weight it deserves. And unfortunately, at every single junction, the Supreme Court said, no, we're not going to do that. But if you sense your frustration, I think you're right. That why they keep litigating on the same clause over and over again. By the next round of cases we'll do later in the semester, they already gave up on it. By the 1880s or 90s, they gave up on the privileged immunities. They almost said, nah. It's a dead cause at this point.
Thank you.
Yep, you're welcome. Okay, any questions left on minor? Let's go on to another case, Strauder versus West Virginia. Ian, what happened in Strauder, please? I'm sorry, you gotta speak up, I'm really sorry. Okay. Okay, good. So Strauder was an interesting case. This may not surprise you, but in West Virginia in the 1870s, it was very hard for a black man to get a fair trial on a murder conviction, right? This was a very hard deal. And what made it so difficult was that West Virginia had a law in place that said only white men can serve on the jury. Okay? This wasn't a case where, you know, they seat a jury and then the prosecutor throws out all the black people who are seated. That's a different story. Here, you weren't even going to call any black men in to sit in the jury pool to get to 12. Okay, they weren't even allowed. So Strauder made two claims. He first claimed that this statute limiting juries to whites was unconstitutional. It violates the 14th Amendment. Specifically, it violates his right to trial by jury. Wait a minute, Josh. Where does this right to trial by jury come from? If you notice, he says under the state constitution. This is an important point which you might have glossed over. He wasn't asserting the constitutional right to a trial by jury. He was asserting under the state constitution the right to trial by jury. The first issue is whether the state law limiting juries to white men violates the 14th Amendment because he's not getting a fair trial, a right to trial by jury. Everyone get that?
Can you say that one more time, please?
Yeah. This is not a case where he's relying on the federal constitutional right to a jury. West Virginia had a jury trial in their state constitution. And what he's saying is that jury trial in the state constitution was not being applied equally, that the state law itself was not being applied without classifications. Everyone see that? Okay. But the second issue is more interesting. He sought to remove the case to federal court. Did you study, Connor, did you study removal in CivPro?
Yes.
Remember how that works?
I mean, not entirely, but. I mean,
More or less.
I think so.
What's the gist?
I think you can, like, remove the jurisdiction to where it's more favorable to you, like, or to where it's
What are the
not-
grounds that allow you to remove it? Got it.
Diversity.
A federal cause of action, right? So if you're being, I like walking around. I feel like I'm beating a turf. Sorry. So some professors like walking around. I don't. I'll let you have your room. I have mine. So generally speaking, if you have a state cause of action and there's some sort of federal issue, diversity or whatever it's going to be, the defendant can remove it or transfer the case to federal court. And the thinking goes, you get a more fair forum. Rather than having a local jury, a local judge, you get a federal judge who's supposed to be independent and neutral and all that jazz. So Congress passes a statute saying, hey, if you are a criminal defendant and you're in a place that's depriving of your civil rights, come to federal court. We'll give you a fair forum. We'll give you a jury with people, white and black, everything in between, right? Come to us, right? Come to us. Was that constitutional? Could Congress step in and take the case away from the state courts? Right, so these are the two questions. Was the statute discriminating based on equal protection? And could Congress actually allow the removal to these federal courts? Christian, so what did the court hold in the 14th Amendment? A little bit louder, please. Yeah, I know. Why?
Well, because they weren't supporting equal right to,
What did they say was the purpose of the 14th Amendment? Why was the 14th Amendment enacted?
to provide all races, especially black.
Yes, okay, and that's the part I want to stress. The same way that Haley was perhaps uncomfortable about the previous decision, I'm sure others were uncomfortable about this one. So it describes the freedmen as children. That's what it calls them. It says, Their training as slaves had left them mere children, and as such, they needed the protection which a wise government extends to those who are unable to protect themselves. The 14th Amendment was framed to assure the enjoyment of all rights enjoyed by white persons, giving to that race. So what's interesting is that on the one hand, you're saying, yay, Strauder wins, right? But on the other hand, there's a very infantilizing view of the Constitution, that it's meant to help children, and that's the word the case uses, children become free and into society. It's a very odd and almost jarring way to read it. But in the end, the court says that blacks and whites have to stand equal before the laws. And they can't be discriminated based on their color. Now, the court doesn't say that you have the right to people of your own color, right? It's not saying that you have a right to an all-black jury and all-white jury. All it's saying is that you need to be able to seat people in the jury pool to at least have the possibility of having a black member of your jury. Now, this shouldn't come as a surprise to you. What do you think happened, Maurice, once they were required to see black people in the jury? Do you think they were actually put on the jury pool? How come? What'd they do? So anyone know what a peremptory strike is? Right, so you probably did this in CivPro, right? When you have jurors, and a prosecutor can strike them for whatever they want. And invariably, if whatever black people actually managed to make into the courthouse, they were struck. So even though the court upheld the right to a jury, as a matter of practice, right, they were not allowed onto the jury pool. They were all, struck out. And you mentioned literacy tests. Yes, there's actually a passage in the opinion where they said you can limit qualification based on education. So I'm sure if any black person tried to even show up to jury duty, they'll hand them this impossible test which they can't pass. Seriously, Google these. I mean, I've tried taking them. They're impossible. They require you to recite Latin and like geometry and like really like impossible stuff. They're laughable if they weren't true, which is what makes them scary. So the court held that you can't discriminate based on race, but they left open the door for doing other things which are not quite racial discrimination. So what we'll see, if you want to call it a second wave, right, is the initial law said no blacks allowed in the jury, period. Okay, that was struck out. The second wave was, okay, blacks are allowed in the jury, but here, take this literacy test and we'll strike you anyway. So even on its face, the law looked neutral. Under the hood, so to speak, there was other various methods of discrimination going on. Okay? All right, so the last case, oh, yes, ma'am. Yeah, we'll do that towards the end. It's on the syllabus. Yeah, we'll do this in a couple weeks. It's on the syllabus. Yep, we'll do that. Other questions? Yes, sir.
Why is it against the president more than enforces laws? Why is it always Congress's job to keep reacting and creating more appropriate legislation versus against the president? You know what I mean?
What role does the president have to make laws?
You know what I mean? To enforce those laws.
Well, who enforces them? See, what's interesting is that Congress, this we'll do in the next case, right? Oh, perfect. Thank you. Next case. So the very next case, I promise I'll answer your question. You asked about the very next case. So the last case we have for today is called the civil rights cases. Okay? And these cases were actually a series of situations. So Congress passed a law under its Section 5 powers. Okay, what did this law say? The law said that the places of public accommodation, hotels, theaters, restaurants, places of public amusement, etc., right? These places were not allowed to discriminate on the basis of race, right? And Maurice, what happened if one of these places discriminate on the basis of race, what happened to the business owner? Yes. So the executive branch, the president and the attorney general, would prosecute in federal court any business that excluded on the basis of race. So that answered your question? I told you, I was like 30 seconds away, I was close. So the way these cases work is that Congress passed a statute under its Section 5 power saying private businesses cannot discriminate in places of public accommodation. So we have here an opera house. This was an opera house in New York. Believe it or not, New York theaters were segregated. We're not Mississippi. We're in New York. Okay. A McGuire's house in San Francisco. They discriminated as well. They also had significant anti-Asian bias in addition to against blacks. In Missouri, Jefferson City, Topeka Inn. So there were various places in the country, I think there were 5 or 6, I can't remember the exact number, where the businesses discriminated on the basis of race. They were prosecuted in federal court, and I think they were fined. I don't think there was jail time. I think they had to pay a penalty of some sort. The businesses went to court and they challenged their conviction, and they argued that it was unconstitutional, that Congress could not require them to open up their businesses to anyone they wished. Okay? So you've all studied, I'm sure read about the case called Plessy versus Ferguson. We'll do that, I think, next class, maybe the week after. This was the famous case where you had segregated rail cars, and they had a white car and you had a black car. And the Supreme Court said an opinion that this was fine because separate is equal, right? As long as the accommodations are equal and if they're separate, that's fine. That case was not nearly as important as this case. Everyone knows about Plessy. No one knows about the civil rights cases, right? This case was so much more significant because it applied to a much broader scale. The Reconstruction Congress wasn't just interested in desegregating government institutions, right? That was important, but their vision was much broader. Their vision was to require private places to open up their doors to everyone, regardless of their race. It wasn't enough to make the government open, allow the governments to admit blacks on juries or whatever else. Private businesses had to open up their doors. Okay? In Plessy, you may have studied, there was a vote of 8-1. And only dissent by Justice, who's my man. I'm a huge Harlan fan. I've named it. The nonprofit that I run is named after him. Justice Harlan dissented in Plessy, saying that we have a colorblind constitution, that separate cannot be equal. Okay, we'll discuss that next week. But Harlan was also the only dissenter in the civil rights cases. 8-1 vote. This one wasn't close. It wasn't 5-4. All right, so let's talk about the actual decision itself. And let's go back to the 13th and 14th Amendment. We said that the 13th Amendment is unique in the Constitution because it applies to individuals. Private individuals, private businesses cannot engage in slavery. It shall not exist. No slavery can exist. In contrast, the 14th Amendment operates on states. No state shall make or enforce any law. No state shall deprive, right? Everything in the 14th Amendment is about states. Okay? This is what became known as the State Action Doctrine. Write that down. The State Action Doctrine. The idea is the 14th Amendment limits state actors. The state, city, mayor, governor, policeman, firefighter, whatever. any state officer who's clothed under the color of state law is bound by the 14th Amendment. Are you or I bound by the 14th Amendment? No. If an individual in his home says, you know what? I don't want to invite anyone over for dinner who's black. Okay, we will shame that person, say he's a very bad person, but is he acting unconstitutionally? No. Right? If a person says, you know what? In my business, I don't want to hire any black people. I don't want to hire women. Is he violating statutes? Sure. There are lots of statutes on this point. Was he violating the Constitution? No. If a person says, I will hold you as a slave and I will not let you go, is he engaging in a constitutional violation? Yes. So everyone see the difference. The 13th Amendment applies to individuals. The 14th Amendment has a state action department. Raising your hand? So this poses a problem. How can Congress require that businesses open up to blacks and whites if they can't act on individuals? That's the issue of the civil rights cases. And again, by a vote of 8-1, 8-1, the Supreme Court said the 14th Amendment does not apply to individuals. The 14th Amendment does not give Congress the power to require businesses to do this. That this is a quintessential aspect of the police power, which Congress lacks. That Congress cannot enact what they call a municipal code over all the little details of how businesses must operate. Right? Congress simply cannot do this. All right? What does Justice Harlan say in dissent? And his dissent is very interesting. He makes a couple points about the 13th and 14th Amendments. So first, about the 13th Amendment. He looks at the word slavery, right? He doesn't read slavery to be so narrow. He doesn't read slavery to simply be having someone locked up in chains and unable to leave and making them work. He speaks of badges of slavery. Morgan, what are these badges of slavery?
It's more of a civil freedom than an institution. So when the 13th Amendment abolished slavery, it abolished pretty much these badges of discrimination.
Right. Well, what are these badges? What does this mean?
Because they're, I mean, do we list them like the use of
Describe it.
the railroads and public highways? You have the right to use those as a.
What's a badge of slavery? You're right.
Oh.
Yeah.
They're propositions which ought to be deemed indisputable.
No, not exactly. Where'd they go?
These fundamental rights.
No. Zachary, what are these badges? What's a badge? What's a badge?
A badge is something you wear in honor, but it's ironic because they're seeing the badges of slavery, things that following civil rights amendments that essentially African Americans were still oppressed by the institution of slavery, regardless of whether it was.
Yes, exactly. These badges, call them reminders, right? You ever read the Scarlet Letter? You know that book where Hester Prynne's were an A to mark her for adultery? That was her badge of dishonor. Badges you don't have to be for honor; they can be dishonor. What Harlan's saying is like this: even though the institution of slavery has been eliminated, there are these reminders, these vestiges, these badges, if you will, of slavery, to remind them that they are a subclass. Harlan writes that even though they're not actually in chains, the institutions of civil society remind them and everyone else on a daily basis that they are not equal. So sure, they're not slaves anymore. But if they want to go to a movie, well, there are no movies. They want to go to a theater or a restaurant or a hotel or a park, and then someone says, no, you can't enter. That says a lot. It tells the person that you're not worth it, you're not a full person, and it tells to everyone around them, okay, you can dump on these people because they're not full citizens. By allowing this form of discrimination to persist, Harlan writes, you're actually keeping people as if they have their chains on, right? They're still wearing these badges or incidents of slavery so that they're reminded of where they were. So Harlan says, listen, let's not be so narrow and silly, right? These aren't some, children, whatever. They just fought and had this war and were oppressed for all these years. So Harlan says, I will read slavery to be a concept and that Congress can take steps to remedy this problem. And that goes far beyond taking away a person's change, so to speak, and allows them to eliminate these reminders. Okay? So Harlan would read this badge of slavery very broad. Okay? That doesn't get you to gender, though, which is interesting. Harlan's reading was so narrowly focused on race and the freedmen, it doesn't get him anywhere to gender, which is a side note. But Harlan would give a very broad power over this. So let me ask Jonathan this question. And then we'll do this. Someone mentioned affirmative action. We'll do this later. If we're talking about vestiges or reminders of slavery, how long does that last for? At what point are we past the point of reminders of slavery? That's why I asked it. By the way, I remember when I was a 1L or 2L, I did oral arguments. And so there was some judge, and he asked a really good question. I said, that's a really good question. He's like, I know, that's why I asked it, so answer it. So anyway, why is it a good question?
Well, according to Harlan's stuff now.
We mean now, today?
Well, when he was writing this in 1883, he's saying that these badges need to be eliminated.
Right, but at what point are they eliminated? That was the question I asked.
Start listening to them.
What?
When the southern states start listening to the federal court.
So like in year 1970, 1980, 2000, 2010.
I mean, I guess the civil rights act.
So this is an open question, and this is actually a raw issue, and I mean raw, on the Supreme Court today, where the justices disagree strongly about this, about whether the so-called times have changed, and we'll discuss this later. But Harlan's opinion, by tying it to these past transgressions, invariably puts a time limit on it. He's not saying we have this for the sake of equality. He says we have this to get rid of these badges. But at some point, invariably, do these badges disappear? Okay, and this is a raw issue that the Supreme Court do not agree over today. The second ground, he argues, is actually under the 14th Amendment. So even though it says no state shall deny any equal protection, Gabrielle, are hotels and restaurants in these places actually private businesses? What does he say? Emily? Why not? George? Yes. Remember common carrier? You say that in contracts or torts? What's a common carrier, George?
I think that's used by everyone.
Yes. Generally speaking, common carriers, rails, highways, hotels, whatever, they have historically been regulated by the state to have open access. That if you have an empty bed and someone's willing to pay your price, you have to give them the bed. Right? If someone wants a train ticket and they can pay the price, you let them on the train. If someone wants to watch a show and they have the money for a ticket, you give them a ticket. Harlan says, wait a minute. These common carriers, which have existed at common law for hundreds of years, are in fact state-run entities. So it's simply not true that this theater is a private business. It's a state business. Whoa. James, what's the implication of that then? If any business that serves the public is now a state enterprise, what's the significance of that opinion?
They can't deny people based on
Big picture, what happens now if Congress can reach all these businesses?
it's just a reaching power. They have more ability to regulate.
No, it would go into, like, other articles would apply to states.
Yeah. Right. So Harlan has to be very careful here. And the reason why he has to be careful is because this could potentially blow up. By giving Congress the power to regulate private businesses, this drastically changes the police power. So he tries to limit, saying, oh, no, these are just common carriers. I'm not talking about anyone else, right? If you run a private business, say like, I don't know, you're a blacksmith or whatever, right? And if you don't want to serve a black customer, you can do that. But Harlan says for private businesses. There's also one part of his opinion, Gabrielle, where he talks about the Commerce Clause. Did you notice that towards the end? Anyone see? We're running a little bit low on time.
You said the Commerce Clause?
He mentions it briefly. Anyone see that? So Harlan, again, this is 1880 whatever, right? He is so far ahead of his time. And I'll give you an anecdote. While Justice Harlan was on the Supreme Court, he taught constitutional law at George Washington Law School. Can you imagine how cool that is? Taking constitutional law from a sitting Supreme Court justice. And I'll give you one cooler. One of his students transcribed his lecture notes verbatim. I actually published the entirety of them. It's a transcript, 400 pages, the entire semester of constitutional law from Justice Harlan in the 1898 or 1899. And he had such foresight. He recognized years ahead the Commerce Clause. He knew where this was going. He had such foresight. So he says, listen, wait a minute. If you're taking a train from one state to another, you can't deny a customer a ticket based on his race. That's violating, that's impeding interstate commerce. And that was the Shreveport rate case we do later. So there's a serious amount of foresight in Harlan's opinion. But alas, Harlan loses. He was only one for the dissent. And unlike his dissent in Plessy versus Ferguson, which carried the day when Brown reversed those cases, the civil rights case is still bad law. I mean, well, it's bad, but it's still good law. It's still current. And Congress has never fully grasped its powers to use Section 5 to enforce civil rights. Is your hand up? So Congress has never really embraced Section 5. So the same way that Slaughterhouse killed privileges and immunities and pushed us to due process, civil rights killed Section 5 and pushed us to the Commerce Clause. The reason why all of the civil rights laws we studied in Hearts of Atlanta and Katzenbach were Commerce Clause regulations was because of the civil rights cases. Because the Supreme Court said that we can't regulate private businesses under the 14th Amendment, let's go to the Commerce Clause. So you can see here, we went backwards in this course a bit, but the reason why we've gone through all of these various loopholes of due process and commerce was because the Supreme Court messed it up in the 1870s and 80s. We had decisions that were wrongly decided then, and forced future generations to look to other clauses of the Constitution. Okay? In our next class, we will be focusing on Section 5 of the 14th Amendment. Congress has tried to do some stuff under this, and in recent years, the Supreme Court has, shall we say, ratcheted back and found that various efforts to pass major laws that infringe on state sovereignty are unconstitutional. Okay? We won't be talking about using Section 5 to enforce civil rights, but using Section 5 to intrude on states. And that's the subject for our next class. Okay? Any questions? All right, I am off to the Supreme Court today. I'll be online tomorrow morning, and I will report back on Thursday for the Obamacare case. We argue tomorrow at 10. Have a good night, everyone. Another airplane for my ear. Perfect. Not joking. Oh, so many times. My God, I've been doing it for the past 24 hours. It's killing me. It's awful.